Welcome to the Consequential Actions podcast, where we aim to learn how history impacts current events and affects our lives today through the lens of politics, the economy, technology, and business trends. I may be an AI, but your host, well, he is not artificial in any way. Here is Jeff Kellick.
New York City, 1968. John Kelly receives a notice from the city's Department of Social Services. His welfare benefits, aid to families with dependent children, are being terminated. Immediately. No hearing, no explanation beyond a form letter. Kelly had been receiving about $200 a month to support his family. Now, nothing. The notice says he can request a hearing to contest the termination, but it all happened weeks after his benefits stopped. In the meantime, no income, no way to pay rent, no way to feed his children. Kelly sues, and his lawsuit will reach the Supreme Court in a case called Goldberg v. Kelly, one of the most consequential decisions in American welfare law. The question before the court is simple. Does the government have to give you a hearing before cutting off your welfare benefits? But beneath that procedural question lies something much deeper. Are welfare benefits just government generosity that can be revoked at any time by any will? Or are they a form of property that you own, protected by the Constitution's guarantee of due process? If welfare is property, then government can't take it without notice, a hearing, and procedural safeguards. Just like government can't seize your house without due process. It can't seize your benefits without due process. And if welfare is property, then the welfare state is not temporary. It's permanent. Because property rights are constitutional rights, they do not depend on legislative generosity. They're entitlements you can demand. This is where the Great Society legislative programs become constitutionally entrenched, where statutory benefits transform into judicial rights, where dependency gets formalized through legal doctrine. Welcome to the proceduralization of dependence. The moment when welfare becomes something you own, not something you're given. I am Jeff Kellick, and this is From General Welfare to the Great Society. Today, Episode 7, The New Property, Welfare Rights, Goldberg v. Kelly, and the Proceduralization of Dependence. To understand Goldberg v. Kelly, we need to go back to 1964, the same year LBJ launched the Great Society. A Yale professor named Charles Reich published an essay in the Yale Law Journal titled The New Property. It's one of the most influential legal articles of the 20th century, and it laid out the conceptual foundation for transforming welfare from charity into a constitutional right. Let me walk you through Reich's argument because it's brilliant, if not deeply troubling, depending on your perspective. Reich's observation. In the modern administrative state, Reich argued, most Americans depend not on traditional private property, land, goods, capital, but rather on government largesse, government jobs and pensions, professional licenses required to work, government contracts for business, subsidies for farmers and industry, welfare benefits for the poor, Social Security for the elderly, broadcast licenses for media, and occupational permits for trades, just to list a few of those. Reich's point was, for most people, wealth doesn't come from owning things. It comes from government's permissions, government jobs, government benefits. This is his passage, and I want to quote this directly. Government largesse is today the principal source of wealth. For a large number of people, government largesse is the only form of wealth they will ever have. It is the foundation of individual status, wealth, and security. So, again, Reich's argument, if government largesse has replaced traditional property as the foundation of economic security, should it not receive the same constitutional protections as traditional property? The Fifth Amendment says government cannot take your property without due process. Historically, that meant your land, your possessions, your business. But if your welfare check is your primary source of income, if it's the property that sustains you, should not the due process clause protect it too? Now, Reich argued that the modern state creates wealth, distributes wealth, and controls access to wealth. Almost everyone depends on government in some way through jobs, licensing, contracts, or benefits. If government can arbitrarily revoke the largesse without hearings, without reasons, without protections, then citizens become subjects. Economic security becomes contingent on a bureaucratic whim. Therefore, government benefits should be treated as new property, protected by the same constitutional guarantees as traditional property. Now let's pause and consider what Reich is saying here. There's an appeal to this, that Reich is saying that he identified something real. In the administrative state, government does control access to economic opportunity. Getting fired from a government job without a hearing seems arbitrary. Losing a professional license without due process seems unfair. And having welfare terminated without explanation seems cruel. If these are your means of survival, shouldn't there be procedural protections? Of course, the libertarian concern is Reich's argument proves too much. If government benefits are your property, then 1, government becomes the universal property creator. Your property isn't something you earned or produced. It is something government granted. And what government grants, government defines. 2, there's no distinction between public and private anymore. If welfare is property, like your house is property, then dependency and autonomy are morally equivalent. And 3, government becomes the universal landlord. Everyone depends on largesse. Everyone is a tenant. Economic independence, which libertarians see as a prerequisite for political independence, disappears. If statutory benefits become constitutional entitlements, they can never be reformed. Once welfare is property, cutting welfare is taking property without due process, then those programs become permanent. Here's the deepest problem. Reich's observation is accurate. Government has become the source of most economic security. But is the solution to constitutionalize that dependency, or to reduce that dependency by limiting government's role? Reich says, accept government as the provider and demand procedural protections. Libertarians say, reduce government provisions, restore economic independence. Reich's article was published in 1964. 6 years later, the Supreme Court would adopt its theory almost wholesale in Goldberg v. Kelly. And with that decision, welfare would cease to be charity and become constitutional property. March 23rd, 1970, the Supreme Court decides Goldberg v. Kelly. Let me set up the facts carefully because understanding what happens matters. The facts: New York City terminates welfare benefits for John Kelly and others without a pre-termination hearing. Recipients get a form letter saying their benefits are ending. They can request a hearing, but it happens after termination. The city's reasoning is, we need flexibility to stop payments quickly when people become ineligible. Administrative efficiency requires cutting off the benefits first, hearing appeals later. Otherwise, fraud continues during lengthy hearings. The recipient's argument: welfare provides the means to obtain food, clothing, housing, medical care, the necessities of life. Cutting it off without warning can lead to immediate crisis, eviction, starvation, illness. Due process requires notice and a hearing before deprivation. You can't take property without due process. Welfare is property. Therefore, we need a hearing before termination, not after. The constitutional question is welfare property protected by the 14th Amendment's Due Process Clause? Justice William Brennan writes the majority opinion. It's a 5-3 verdict, and it's one of the Warren Court's most consequential decisions about the administrative state. Brennan writes, welfare provides the means to obtain essential food, clothing, housing, and medical care. It's the very means by which to live. Then the crucial line: such benefits are a matter of statutory entitlement for persons qualified to receive them. The constitutional challenge cannot be answered by an argument that public assistance benefits are a privilege and not a right. Do you hear what Brennan just did? He rejected the traditional distinction between rights and privileges. For centuries, courts had said government benefits are privileges. Government can grant them or not, attach conditions, revoke them. You have no constitutional claim to government generosity. Brennan says, no. Once government creates a benefit program and makes you eligible, you have a property interest in receiving it. It's not charity anymore. It is entitlement. What the court required was, for welfare termination, due process requires 1, notice, specific, timely, explaining why the benefits are ending. 2, an opportunity to be heard before termination, not after. 3, an oral hearing, not just written submissions. 4, a right to confront the evidence, see what the agency is relying on for this benefit determination, eligibility determination. 5, the right to present your evidence, your own witnesses, your own documents. Also, 6, an impartial decision maker, someone not involved in the termination decision, i.e., not an agency representative. And then 7, a written decision explaining the reasonings of the outcome. That's not administrative convenience. That's a full-blown trial type of hearing before you can cut off someone's welfare check. Now, here's what's fascinating. Justice Hugo Black dissented. And Black was a liberal, a former Democratic senator, an FDR appointee, a champion of civil liberties. But Black thought Goldberg went too far. Black said, the Constitution does not mandate these extensive procedural requirements. Due process has some core protections, sure, notice, some opportunity to be heard, but trial-type hearings before every welfare termination? That is not in the Constitution. This is the court imposing its own policy preferences, not interpreting law. If New York wants to provide hearings, fine, but the Constitution does not require it. Black's dissent is significant because it shows how controversial Goldberg was even among progressives. This wasn't a clear-cut liberal versus conservative split. It was a question about how far procedural rights should extend. What Goldberg meant in practice was that welfare agencies had to hire administrative law judges, schedule hearings, maintain hearing facilities, keep detailed records, provide written decisions. The administrative costs exploded. Welfare bureaucracy grew, processing times increased. Did this help recipients? Sometimes. Wrongful terminations got corrected. Arbitrary decisions got reviewed. But did this create problems? Also, yes. Administrative bloat, delays, costs. and the fundamental shift from welfare as temporary assistance to welfare as permanent entitlement. Goldberg didn't just require procedures, it changed the nature of the citizen to state relationship. Before Goldberg, welfare is legislative generosity. Government provides benefits because it chooses to. Citizens are recipients, grateful for assistance, and government can modify or eliminate programs as it sees fit. After Goldberg, welfare is a constitutional property. Government must provide to eligible persons. Citizens are rights holders demanding entitlements, and government cannot easily reform the programs. This is Charles Reich's new property, its theory becoming constitutional law, and it fundamentally altered the welfare state. Programs created by Congress, which Congress could presumably modify or eliminate, now have constitutional protection. Not absolute protection, but procedural protection that makes reform very difficult. From a libertarian perspective, this is the final step in making the welfare state permanent and irreversible. Legislative programs become administrative entitlements. Administrative entitlements become constitutional property, and constitutional property becomes immune to democratic revision. But from a progressive perspective, this is necessary protection for vulnerable people. Without procedural rights, bureaucracy becomes arbitrary, power without accountability, and Goldberg ensures dignity and fairness. Both perspectives have merit, and it's that tension between efficiency and fairness, between flexibility and protection, that runs through all administrative law. Six years after Goldberg, the Supreme Court realizes it created a problem. If every government benefit requires full trial-type hearings before termination, the administrative state grinds to a halt. The costs are unsustainable, and the delays are enormous. It takes us to Matthews v. Eldridge in 1976. George Eldridge is receiving Social Security disability benefits. The Social Security Administration determines he's no longer disabled and cuts off his benefits without a pre-termination hearing. Eldridge sues, citing Goldberg. Says, "You can't take my benefits without a hearing first. Benefits are property. Due process applies." The government responds, Goldberg was about welfare, assistance to the destitute. Social Security is different. Insurance benefits based on work history, and the administrative burden of pre-termination hearings would be crushing. Justice Lewis Powell writes the majority opinion, and he does something important. He creates a balancing test to determine how much process is due. Powell says, due process isn't all or nothing. You do not automatically get full trial-type hearings. The courts must balance three factors. Factor one, the private interest affected. How important is this to the individual? On Goldberg, welfare is survival. Eldridge, the disability benefits are significant, but less immediately critical. Factor two, the risk of erroneous deprivation and value of additional procedures. How likely are mistakes? Would more procedures reduce errors significantly, or are the existing procedures adequate? And then factor three, the government's interest, including the fiscal and administrative burdens. What does it cost to provide additional administrative procedures? How much does it interfere with efficient administration? In Eldridge's case, the court held. Social Security disability determinations are based on medical evidence, which can be reviewed from written records. Oral hearings don't add much value. The risk of error is lower than welfare, and the cost of pre-termination hearings for millions of Social Security recipients would be enormous. Therefore, post-termination hearings are sufficient. Due process does not require pre-termination hearing for Social Security disability. Matthews created flexibility. Not every benefit requires Goldberg-level protections and procedures. The courts then balance the interests. So, to recap, Goldberg was welfare for the destitute. Pre-termination hearings became required. In Matthews, it was Social Security disability, and therefore post-termination hearings were acceptable. This became known as the Matthews balancing test, and it's how courts decide procedural due process cases all the way to today. Now, thinking about this from a libertarian, Matthews says the state must be polite before taking your property, but it can still take it. Procedures are required, but not necessarily extensive procedures. Government gets to consider its own administrative convenience when deciding how much due process. This is procedural due process without substantive limits. Government can create benefits, revoke benefits, modify benefits, as long as it follows procedures. The Constitution doesn't ask, should government have this power? It asks, did government follow proper procedures in exercising this power? Justice Rehnquist's concurrence in Matthews pointed this out. He wrote, and I'm paraphrasing, the Constitution does not require procedures so comprehensive as to transform the hearing into a trial. But that raises the question, if procedures can be minimal, just enough to avoid being arbitrary, what protection do they really provide? Some, more than nothing. Agencies can't act arbitrarily. They must provide notice, some opportunity to respond, some reasoning. But it's a far cry from the robust protections that Goldberg seemed to promise. Matthews represents the mature administrative state settling into manageable routines. Goldberg was idealistic, full due process for everyone. Matthews is more pragmatic, balancing interests, managing costs, keep government functioning. The result? Proceduralization of dependence. You have property interest in government benefits, but your protection is procedure, not substance, process, not power. And that's the world we live in today. Now, Goldberg and Matthews were not isolated cases. They were part of a broader movement in the 1960s and 70s to extend procedural due process throughout the administrative state. The logic spread, if welfare is property, what else is property? Government employment. In the Board of Regents versus Roth in 1972, a teacher's contract is not renewed. No hearing, so he sues. The court holds government employment creates a property interest only if there's a legitimate expectation of continued employment, such as tenure. Without tenure or a contract promising renewal, there's no property interest, no due process required. This clarified that not every government benefit is automatically property. You need some legal entitlement, a statute, contract, regulation, creating this expectation of continuation. Then there was Perry v. Sinderman in 1972. It was decided the same day as Roth, and the court held, even without formal tenure, you can have de facto property interest based on established practices, implied promises, or institutional customs. So together, Roth and Perry created a framework. Its property interest in government jobs depend on whether there's a legitimate claim of entitlement, not just hope or desire, but legal expectation. In Goss v. Lopez in 1975, high school students were suspended for 10 days without a hearing. So they sue. The court holds that students have a property interest in public education. This is created by state law making education compulsory and free. Therefore, due process applies to suspensions. This is the key language from that. Even short suspensions require notice of charges, explanation of evidence, and an opportunity to tell their side. So, education, once purely a local function, now has constitutional procedural protections. Principals can't just suspend students arbitrarily, they must follow due process. And then what about occupational licensing? During that same era, multiple cases are held. If state law creates a licensing system, the license is property. Government cannot revoke it without due process, notice, hearing, findings. The pattern across all these cases: step one, identify a government-created benefit, welfare, job, license, service such as education. Step two, determine if there's a legitimate claim of entitlement, a statute, regulation, contract creating expectation, or even just institutional norms. Step three, if yes, it's property under the Due Process Clause. And then step four, government must then provide procedures before depriving it. But how much procedure depends on the Matthews balancing test. The consequences of constitutionalizing the administrative relationship are many. First, entitlement culture is expanded. Benefits become rights. Recipients become right holders, and dependency becomes dignified. Second, litigation explodes. If every benefit is property, every termination is a due process case. Courts flooded with administrative challenges. Third, the bureaucracy grew. Each procedural right requires administrators, hearing officers, lawyers, record keepers. Fourth, then, programs become much harder to reform. You cannot easily modify entitlements without violating these property rights. And then fifth, politics became judicialized. Disputes that were political, how generous welfare should be, became legal. Are the procedures adequate? F.A. Hayek argued in The Constitution of Liberty that state-provided security makes individual freedom contingent on bureaucratic discretion rather than general rules. When most economic relationships run through the government, everyone becomes a subject. Personal independence, economic autonomy disappears. Goldberg and his progeny confirmed Hayek's fear. The modern citizen isn't independent. They're entangled in administrative processes, dependent on government largesse, claiming procedural rights, but not substantive freedom. Progressives, they view it as without procedural protections, administrative power becomes arbitrary. At least due process provides some accountability, some check on a bureaucratic whim. Maybe the question isn't whether Goldberg was right or wrong, but whether we had already gone too far down the path of government provision before anyone thought to ask about procedural protections. Let's step back and look what happened philosophically. The founders built a constitution of pre-political rights. Rights existed before the government. They were natural, inalienable, inherent in human beings, God-given. Government's job was to secure these pre-existing rights, not to grant them, not to define them, to protect them. But by the 1970s, that framework had somewhat inverted. The original constitutional design that rights existed prior to government, life, liberty, property, that government must not violate those rights, and due process means procedures before government takes what's yours, before imprisoning you, before confiscating your property. And your property It's what you produced, you earned or acquired. The new constitutional reality, rights are created by government, welfare, benefits, licenses. Government grants and defines those rights. Due process means procedures before government revokes what it gave you. Your property is government largesse. This is post-political rights, rights defined by the state, enforceable only through the state. Political theorist Richard Epstein observed, the welfare state cannot distribute benefits without simultaneously assuming the power to ration them. Once government becomes the source of security, it also becomes the source of insecurity. You have property in your welfare check, but only if you maintain eligibility, only if you comply with regulations, only if you navigate bureaucracy successfully, and only if the government is not in government shutdown. You have rights, but they're rights to process, not rights to outcome. They're rights to hearings, not rights to benefits. They're rights to procedures, not rights to autonomy. Now, the courts of this era did not see themselves as enemies of liberty. They saw themselves as the tool to rationalize modern governance. Their goal was balance, not boundaries. Fairness, not limits. They accepted that the administrative state is permanent. Their question was not, should government have this power? It was, how can we make this power's exercise fair? But from a libertarian view, of course, balance without boundaries is drift. When every interest is weighed against the government always tips the scale. Procedure without principle isn't protection, it's paperwork. So that's how programs became property, how legislative generosity became constitutional entitlement, how dependency got formalized through legal doctrine. Charles Reich's new property theory in 1964 identified that government largesse had replaced traditional property as the foundation of economic security. And in Goldberg v. Kelly in 1970, constitutionalized that observation. Welfare became property protected by due process. Matthews v. Eldridge in 1976 rationalized it, creating a balancing test to manage the administrative burden. And throughout the 1970s, the doctrine spread. Government jobs, public education, occupational licenses, all became property requiring procedural protections. And the result is what we live under today. Nearly every federal benefit, disability, Medicare, Medicaid, food stamps, student loans, housing assistance, operates under the Goldberg-Matthews framework. You may not have the right to the benefit itself, but you have the right to due process before losing it. Notice, hearing, decision, maybe even appeal. Critics call it due process without due liberty. Procedural divorced from principle. You get paperwork and hearings, but the fundamental relationship of dependency remains unchanged. Defenders call it essential protection, accountability and fairness in the administrative age. Without it, bureaucracy becomes tyranny. The Great Society created the programs. Goldberg made them constitutional rights. Together, they ensured the welfare state's permanence. And they set up a fundamental challenge for the conservative movement of the 1970s and 80s. How do you roll back a system that's become constitutionally entrenched? Next time, the conservative counter-revolution. Reagan and the limits of rolling back the state. Nixon's new federalism that wasn't. The intellectual revival. Friedman, Hayek, Buchanan, Rothbard, building the case for limits. Reagan's rhetoric about getting government off our backs, and the reality why the administrative welfare state once built proved nearly impossible to dismantle. Until then, think about this. Goldberg was decided with good intentions, protecting vulnerable people from arbitrary bureaucracy. But good intentions don't determine consequence. Did proceduralization of welfare rights protect dignity? Or did it institutionalize dependency? Did it make government more accountable? Or did it make reform impossible? Is there a difference between having property in your own earnings and having property in government benefits? Does the Constitution protect both the same way? Should it? And when you think about that, when you think about government benefits, consider how the government acquires the ability to provide benefits. To do this, it must confiscate, it must take from the people. Thanks for joining me in this dive into procedural due process and welfare rights. It's a bit technical, more so than most of our podcasts, but it does matter to understand how this rollback becomes so difficult to change. It's how the welfare state itself became permanent. And with that, I am Jeff Killick, and this has been From General Welfare to the Great Society on the Consequential Actions podcast. If you enjoy this type of content and exploration of history, be sure to subscribe to our Substack page at consequentialactions.com and check out our written articles as well. From our corresponding articles on this, the General Welfare Clause, to what happens after the Cold War through to present day, as well as our detailed analysis of U.S. political theory, economics, and technology. We continue to post articles and welcome your participation at consequentialactions.com or follow me on X at jkillick. Until then, have a great day.